don't think unless there are any other matters that I need to...
Thank you very much. Ms. Stenfield, was there anything that the Crown wished to raise in response?
No, there isn't. I can assure my Lord that Ms Bennett-Jenkins and I have been liaising across this morning, and anything that the Crown needs to feed into the proposed conditions, I have done so. So that which is before my Lord reflects the joint agreement, if I can put it that way, of how this matter can proceed.
Very good. I'm grateful for that. This is an application for bail by the defendant, Christopher Morris Brown, made on notice to the prosecution in accordance with the criminal procedure rules. It is his first application to this court after his remand in custody by the district judge in the magistrates' court. Full argument for bail was heard before that court. It was refused on the basis of a single ground, namely that there were substantial grounds for believing that the defendant would fail to surrender. This was based on the assertions that the defendant had previously failed to attend a voluntary police interview. He had means enabling him to leave the jurisdiction, his lack of community ties, the breach of a previous court order, namely a probation rehabilitation order made in about 2014, to which I shall come shortly, and the nature and seriousness of the offence alleged. The court considered then that security of £250,000 would have little impact on the defendant, and that this would not allay the fears that he would fail to surrender to custody if granted bail. The defendant stands charged with a single count of causing grievous bodily harm with intent, contrary to the Offences Against the Person Act 1861. The Crown alleges... Yes, thank you, Ms. Bennett-Jenkins. I understand that as a result of further inquiries, an additional package is now offered.
And we've got further details of that in the digital case system for my Lord to consider.
Thank you. Thank you very much. Anything further?
I don't think unless there are any other matters that I need to...
Thank you very much. Ms. Stenfield, was there anything that the Crown wished to raise in response?
No, there isn't. I can assure my Lord that Ms Bennett-Jenkins and I have been liaising across this morning, and anything that the Crown needs to feed into the proposed conditions, I have done so. So that which is before my Lord reflects the joint agreement, if I can put it that way, of how this matter can proceed.
Very good. I'm grateful for that. This is an application for bail by the defendant, Christopher Morris Brown, made on notice to the prosecution in accordance with the criminal procedure rules. It is his first application to this court after his remand in custody by the district judge in the magistrates' court. Full argument for bail was heard before that court. It was refused on the basis of a single ground, namely that there were substantial grounds for believing that the defendant would fail to surrender. This was based on the assertions that the defendant had previously failed to attend a voluntary police interview. He had means enabling him to leave the jurisdiction, his lack of community ties, the breach of a previous court order, namely a probation rehabilitation order made in about 2014, to which I shall come shortly, and the nature and seriousness of the offence alleged. The court considered then that security of £250,000 would have little impact on the defendant, and that this would not allay the fears that he would fail to surrender to custody if granted bail. The defendant stands charged with a single count of causing grievous bodily harm with intent, contrary to the Offences Against the Person Act 1861. The Crown alleges that in the early hours of Sunday, the 19th of February 2023, at a nightclub in Mayfair called Tape, he unlawfully and maliciously caused grievous bodily harm to Abraham Dior with intent to do him grievous bodily harm. Mr. Dior says the defendant was one of two men who assaulted him. The other was Omalolu Akinlolu, who Mr. Dior knows also as Hoodie. He described them as friends. He'd known the defendant for about 7 years. They had worked together. Mr. Deal was standing at the bar talking to 2 other friends standing next to him. He saw the defendant and Hoodie walking towards him. He described the defendant seemingly in a positive mood, dancing whilst walking towards him. He thought the defendant wanted to greet him and hug him, as they normally do. The defendant was smiling at him. When Mr. Deal leaned towards the defendant and said "yo" to greet him, the defendant hit him 3 times on the left side of his head with a tequila bottle the defendant was holding in his right hand. Mr. Deal moved to get away, but lost his balance and fell to the floor, near to the exit door, where Hoodie kicked him on the left side of his stomach and to both of his legs. The defendant kicked Mr. Deal to the back of his neck. This was captured in CCTV footage, which is exhibited as ALC 1, 2, and 3. The whole incident lasted about 30 seconds. Mr. Deal says he remembers being in atrocious pain in those moments. A member of staff dragged him through the exit door to a studio space behind the door and closed the door so no one could come in. Mr. Deal said he was bleeding from his forehead. One of his friends later took him to St Mary's Hospital where he was treated for his injuries. Police were called. Mr. Deal gave an initial account to police. He was found to have sustained a head injury and a superficial injury to his knee and was discharged from hospital with crutches and pain relief. He received further medical treatment upon his return to Italy. Mr. Deal gave a statement to police later that day. In a streamlined forensic report dated the 15th of May 2025, the records of the emergency department at St Mary's Hospital from the 19th of February 2023 note that on presentation, Mr. Deal reported headache and, quotes, possible loss of consciousness and, quotes, some blurring of vision. His neck and cervical spine, his left upper abdomen and his left knee were all tender to touch. There was a reduced range of movement to the neck and the left knee. A computerized tomography scan of his head, neck, chest, abdomen and pelvis was noted to show no injuries, as did an X-ray of his left knee. A clinical impression of head injury and superficial knee injury was noted. He was treated with morphine, codeine and codidromol and intravenous fluids. A further streamlined forensic report dated the 15th of May 2025 sets out Mr. Deal's subsequent treatment in Italy. On the 23rd of February 2023, at the emergency department at the Via Soia Nicchiolina Infirmia, he reported a headache and pain in his left leg following the assault in London. A CT scan of his head and X-rays of his left knee and leg reported as normal, but on examination there was pain on movement of the knee. He was treated with ibuprofen and discharged with an appointment in the orthopaedic surgery clinic a week later. On the 27th of February, the defendant attended the orthopaedic surgery clinic. His knee was hot to the touch and the movement was limited. The inner side of the knee was tender to the touch. There was some instability of the knee during the arm examination. He was referred for an MRI scan of his knee and advised rest. He was also advised to apply ice packs to the knee several times a day. He was given a 1-week course of Diphorium and anti-inflammatory medication. On the 1st of March, some 10 days after the alleged assault upon him, an MRI scan of Mr. Deal's left knee showed a high-grade injury to a ligament on the inner side of his left knee. Police sought to interview the defendant and Mr. Akinlolu about the allegation. An interview was sought through the defendant's solicitor for the 21st of February 2023, then rearranged for the 2nd of March 2023 at the defendant's solicitor's request. He failed to attend that interview. It was rearranged for the 23rd of March. Again, he failed to attend, apparently due to urgent work commitments. He was given a further opportunity to attend on the 29th of March. Again, he failed to do so. Police then became aware that he had left the United Kingdom and he was circulated as wanted by the police. Police were alerted to the defendant flying into Manchester Airport on the 14th of May 2025. This is the first return he had made to this country. He was arrested by police at his Manchester hotel in the early hours of the 15th of May for the offence which he now stands charged, but may no reply to caution. On the 16th of May, the defendant refused bail, as I have mentioned. The defendant is 36 years old and is a high-profile American singer-songwriter. He has no convictions in this country. He has 2 convictions in the United States. These are convictions for violence, one for what United States law describes as a felony assault from 2009, the other a simple assault from 2013. These offences were committed 12 and 16 years ago when the defendant was aged 19 and 24, respectively. He spent 4 months imprisonment in about 2014 for breaching the rehabilitation requirement of his probation. I'm told that this is the only time he has previously spent in custody. More than 2 years have passed since this allegation in 2023, and the defendant has not been convicted of committing any offences since. His last conviction was recorded over a decade ago, when he was still a relatively young man. He has no convictions for failing to surrender. I take the Crown's case at its highest, as I must do on applications such as this. It seems to me that the evidence against the defendant, which I have taken some care to set out, is very strong. There is a very good reason, one might say even a compelling reason, for him to flee the jurisdiction, given the consequences of what might follow. The defendant says he had no direct involvement in arranging a mutually convenient date for a voluntary interview, nor did he have any direct communication with the solicitors who were said to be acting on his behalf in this matter. He says he did not receive any direct warning or advice about the consequences of not attending the voluntary interview. I do find that surprising. In this country, no solicitor acts without instructions. I'm not told who the police were communicating with in making arrangements for the defendant's voluntary interview, but they must have been speaking with someone who they thought was able to speak for the defendant. The allegation against him is a very serious one. The CCTV evidence appears to show the defendant and another man assaulting Mr. Dior, as he alleges. The defence indicated before the magistrates it is factual denial regarding the allegation and injuries. As to the injuries sustained, and again, the Crown's case at its highest, the medical evidence adduced in the streamlined forensic reports supports the Crown's position. There is a rebuttable presumption in favour of bail and a presumption of innocence. The bases upon which bail can be withheld are contained in Schedule 1, Paragraph 2 to the Bail Act of 1976, with the relevant factors to be considered set out in Paragraph 9. I have had regard to A, the nature and seriousness of the offence alleged, and the probable method of dealing with the defendant for it. B, the character, antecedents, associations and community ties of the defendant. C, the defendant's record as regards the fulfilment of his obligations under previous grants of bail in criminal proceedings, including outside of this jurisdiction. And D, the strength of the evidence of his having committed the offence. On applications such as this, it is necessary for the court to decide whether, whatever conditions can reasonably be imposed in relation to bail, there are nonetheless substantial grounds for believing that the defendant would fail to surrender to custody. And that is the only objection to bail which was initially advanced by the Crown and indeed relied upon in the district by the district judge in withholding bail in the court below. Having said all that out, I was of the view that there are substantial grounds for believing that the defendant would be held to surrender custody if he was permitted to leave this jurisdiction. The conditions initially offered on the defendant's part did not, in my judgment, assuage the concerns expressed in this report. It was for this reason that I asked for further information about the defendant's net wealth. The £2 million security first offered on his behalf might, on one view, seem to be a very substantial sum. On another view, and taking into account how I might now talk about the defendant's net wealth, it might not. With that further information provided to the court, a £5 million security is now offered. This is an unusual application. I bear in mind those who are dependent on the defendant to earn their living over the course of the next few months. From what I am told by Ms. King's counsel, the defendant takes his contractual obligations with the utmost seriousness, and he realises his professional career might fall into ruin should he fail to comply with his bail conditions and fail to surrender to the court as and when required. Taking that into account, the concerns which the court held about flight risk from this country can, in my judgment, be mitigated by a stringent package of bail conditions imposed by the court, including the imposition of a hefty security to secure the defendant's return, and one which is relative to the defendant's means. For those reasons, I will grant the defendant bail on the following conditions. 1. Outside of the following dates which I shall mention, the defendant must live and sleep each night at the address notified to the court. 2. The defendant must surrender to police any passport, including his US passport, or international travel document or warrant in his possession or custody before release from custody. 2. The defendant must not contact directly or indirectly Abraham Dior or Omalolu Akinlolu. 4. The defendant must not attend the Tape nightclub in Mayfair. 5. The defendant must provide security in the sum of £4 million before release from custody. 6. The defendant must provide a further security in the sum of £1 million within 7 days from today. 7. The defendant's US passport to be collected by a solicitor of Hickman and Rose on the 27th of May 2025. And held by a solicitor from that firm between the 27th of May and the 14th of June 2025. 8. The defendant's US passport to be collected by a solicitor of Hickman and Rose on the 27th